Appearances?
Trey Smith for Mary Lou's Macias, and I'm ready to proceed, Your Honor.
Your Honor, this is Todd Wright for defendants, and I believe it's our motion being heard today.
Let's proceed.
Your Honor, on March 16, 2021, the defendant served their second request for production at plaintiff, which consisted of 7 requests. All of these requests were narrowly tailored to apply only to the plaintiff. Her medical care and expenses asserted, and issues related thereto, and all of which were related to and arising out of the May 1, 2019 incident that is the basis of this lawsuit. That is the bounds in which all of this discovery is tendered. It is not directed to any non-party. It doesn't seek any medical issues unrelated to the accident in issue in this case. Nothing. None of these requests seek documentation from any other client of plaintiff's counsel, nor does it seek any information from any other plaintiff, or excuse me, any other patient of any of plaintiff's medical care providers, solely focused on the plaintiff and plaintiff alone. Plaintiff has resisted the discovery for a number of reasons. We know that responsive documentation exists because some responsive documentation to these discovery requests has been produced in records from a certain medical provider of plaintiff, but none has been provided by plaintiff herself. Plaintiff has objected to the discovery on a number of grounds, mainly asserting that the discovery sought is not relevant. The discovery in issue seeks to develop and explore the bounds of the medical provider's right to recover medical expenses from the plaintiff herself.
Let me just say this, because I've read this and I understand why you're doing it. The LOP expenses in this case are incredibly high. I don't say they're excessive, but they are very high. Has anyone read this new opinion out of the Supreme Court, the In re Allstate case that came out last week?
I have. I saw it when it came out Friday midday, Your Honor.
I haven't read it yet. It was cited to me earlier. Does it cover any of this?
I don't believe it covers this, Your Honor, and I'll confess I've only given it a first pass review, but I believe the gist of In re Allstate is that even in the absence of counter affidavits, a defendant is not precluded from contesting the necessity and the reasonableness of medical charges.
Yeah, that's what I thought too. Unfortunately, it's going to make these trials a lot longer, some of them, but
it is a sea change.
Yeah, it's especially in Dallas. So I guess my only point is, generally I would never allow this type of discovery. Is there any new opinions or cases in front of the Supreme Court on this issue? I know this is kind of a hot issue right now.
Well, Your Honor, I think the Haygood opinion speaks to the substance of this discovery. The Haygood opinion uses the word windfall 6 times, 5 times in the body of the main opinion and once in the dissent. And the opinion speaks to the plaintiff's right. The medical bills are only, the recoverable medical bills are only those things that the medical provider has a right to recover from the plaintiff. And if the plaintiff has entered into some contract or agreement that diminishes, alters, or extinguishes that right to recover, I think that's something we're entitled to have discovery on.
A response?
Your Honor, well, to address the court's questions first, I read the recent Supreme Court All-State opinion related to the counter affidavits over the weekend. I didn't see how it changed the relevant case law and the inquiry related to this specific motion in this case at all. So I think, whatever, and I'm not aware of any current Supreme Court cases or pending Supreme Court matters that would touch on these issues related by this motion in this case. But to back up a little bit, this lawsuit relates to a May 1st, 2019 automobile collision. Defendant Hernandez, who was texting while driving, failed to yield the right of way and struck the vehicle in which Ms. Macias was a passenger broadside. She suffered serious injuries and she's had at least 3 surgeries that we claim are related to this crash. These discovery requests that the defendants have submitted here are overbroad. Despite defense counsel's interpretation, many of these discovery requests, and it may not have been his intention, but they do cover other patients, other clients of our law firm, and the most of the requests are way over.
Mr. Smith, let me ask you this. I think we're getting feedback. Can you hear me okay?
Yes, Your Honor.
Yes, Your Honor.
What do you think would be appropriate out of this discovery?
The way it's currently drafted, I don't think anything. Regarding Mr. Wright's assertion that he's arguably entitled to contracts, agreements that alter the amount that's owed, to specifically, I believe in his reply today, contracts, agreements, or understandings that could alter, reduce, limit, or eliminate the provider's right to recovery from Mariluz Macias. If he wants to request that type of information, I'm happy to respond to it after receiving a proper discovery request. But these requests that he served go much further than that. He's attached a couple of LOPs that were submitted to him as part of records that were provided to the providers. The LOPs on their face do not alter, reduce, limit, or eliminate the provider's right to recovery. In fact, they do the opposite of that. So again, the way these discovery requests are drafted, they're overbroad. The case law on these topics are very clear that courts ordering discovery of this type of LOP information is considered an abuse of discretion under mandamus. And for all of these reasons, it's our position that the defendant's motion to compel should be denied.
Okay, I'll go ahead and deny the motion to compel then. I agree that I think the Supreme Court has been edging around at the corners of this, but they haven't addressed this exact issue. And so until the Supreme Court or the Dallas Court of Appeals speaks on this, I'm probably not going to order this type of discovery to occur. I do kind of caution you, Mr. Smith, and I've said this, I don't know if I said this to you or one of your associates at your firm, but this is the type of case that if it goes up on appeal, that $675,000 in LOP doctors could make bad law. But I do think the law is right now that it's not discoverable. So I'll go ahead and deny the motion to compel. Anything else, guys? Have you already submitted an order, Mr. Smith?
If I have not, I will do so now. Do we just file that through the e-service system? Or?
So if you could do this, if you could e-file it as well as email my court coordinator on the order, if you could say on May 10th, 2021, instead of on this date, and submit it to Mr. Wright first and try to get it to us as soon as you can.
Yes, Your Honor, I will do that.
Okay.
Your
Anything
Honor,
else?
yeah, can I impose on the court for just a few moments of direction as to our current trial setting? And I don't know that we need